let's get started here. Welcome, everybody. My name is Eric Hauge. I'm the Executive Director at Homeline, and you're joining us today, us being myself and Homeline's Managing Attorney and Tenant Hotline Director, Mike Bra. You're joining us on Wednesday, May 12th, 2021. And it's 1:30 in the afternoon, and we're going to start another one of our regular COVID-19 pandemic tenant landlord law webinars to cover updates on what's going on with pandemic related eviction suspensions on a federal and a state level. And we'll talk about what's going on at the legislature, discussing a potential end or off ramp of the suspension on the state level, as well as legal challenges to the federal suspension. And then we've got plenty of time for questions as well at the end. So just a reminder about Homeline. We're a statewide nonprofit organization. Our main program is a free and confidential tenant hotline that has advised over 260,000 renter households since opening. And we advise on average about 1,000 households each month throughout the state in 4 languages: English, Spanish, Somali, and Hmong languages. We also have a variety of staff that work besides advising folks on their legal questions on the hotline, also doing tenant organizing, public policy work, and research and education. There's our phone number. You can contact our hotline directly via those numbers if you are a renter in Minnesota and have a question. Again, for today's session, we're going to provide some general information, legal information, and updates on what's going on. If you are a renter and you have a specific question, you're welcome to send questions in the chat or the Q&A, but if you have a specific individual question about your tenancy, it's a good idea to contact our hotline. We have been doing these seminars since mid-April of last year, and they're all available on our website, recordings of previous ones. If you missed the last one, it was a really good seminar on where we were joined by Homeline staff, Leah DeGrazia and Andrea Palumbo, and they went through an analysis of eviction filings during the pandemic for the first full year of the suspension, what types of cases were filed and the numbers and that sort of stuff. So recording and materials for that is on our website. We have a couple seminars coming up next week. And we may, given the unique nature of May and June with the legislative session ending and things like the federal CDC moratorium being challenged and potentially ending in June, we may be doing more regular seminars. But next week we have 2 seminars. If you've been tuning in to our regular session, next Wednesday is going to be another one of our regular webinars, just like today. Legislative session in Minnesota ends. It's supposed to end at midnight on Monday, May 17th, next Monday. And so there may be some sort of information or updates, sort of last minute updates that has happened next Wednesday. So we'll be covering that if there is news, and then answering questions as well. We also are doing a seminar. Additionally on the 19th, Michael Dahl, Homeline's Public Policy Director, will join us for that seminar as he has been following what's going on at the legislature. And then also next Tuesday, so the day before our normally scheduled webinar is we're going to be doing one. It's a different time. So next Tuesday, the 18th, from 12:30 to 2. We are partnering with the Minnesota Engagement on Shelter and Housing Organization, or MESH as it's called, to host a webinar to discuss planning for homeless prevention at the end of the eviction moratorium. And so this seminar next Tuesday is really designed for stakeholders that are involved in the FHPAP, or Family Homeless Prevention and Assistance Program throughout the state. We're going to have a variety of panelists, guest speakers from throughout the state in the different areas of the state to discuss what they're doing and answer questions. And that should be a good opportunity for folks that are engaged in our stakeholders in that program. I will post in the chat the links to register for these upcoming webinars, but they're also available on our website. There's a COVID-19 tab at the top right. Before I hand it over to Mike, we want to make sure that folks are aware of the rental assistance program, the COVID-19 Emergency Rental Assistance Program, through Minnesota Housing Finance Agency and a variety of other county and local governments throughout the state. Renthelpmn.org is the place to get all the information you need to apply and get ready for that program. And if you're a landlord, to find out register and find out more information about how that program works. Renters can also call 211 to get assistance in getting a paper application, or they have questions or need guidance filling out an application. There's sort of an unprecedented amount of federal resources, dollars in the state that are in this program. The program opened on April 20th last month. So it's just getting started, but the money is going to start going out the door after applications are getting submitted. So that's that. The other thing on this, just a little bit of an update that we probably won't share much right now, but there may be news in coming weeks, is that there was new guidance from the federal government on how some of these dollars and future dollars that are coming from that came from Congress through a variety of different funding programs and that Congress approved recently. And that guidance is going to provide potentially some changes in Minnesota about how these programs operate and what might be required in the application process. That hasn't happened yet. It was just guidance that was sent out recently within the past week or so. And so there may be more news on that. But for now, all the information you need to know is on renthelpmn.org. So with that, I'm going to hand it over to Mike Fra. A reminder that we did get a number of questions submitted in advance through the registration system, but we are going to have plenty of time to cover those and any other questions that come up today. So please, it's easiest if you submit your question in the Q&A question and answer system through Zoom, and we'll get to it towards the end. With that, I'll hand it over to Mike. Thanks.
Thanks, Eric. And before I dive into the substance of what I'm going to talk about today, I think I have to mention this is, I know you don't believe the accurate count about this, but I think today is our 50th version of this type of speech. We started doing these April 22nd of last year. And it's not exactly something I want to pop a bottle of champagne open for and celebrate, but it's a milestone that we've done this 50 times. When we started out doing these in April of last year, this was about a month after the first eviction moratoriums were put in place. We didn't know if anybody was going to watch them. We set them up. One was on a Wednesday and the second one was on a Thursday. The first one was 90 minutes and it was for tenants, social workers, that side of the coin. And the Thursday speech was to landlords. We wanted to make sure that we were giving equal time to both groups to answer whatever questions they might have. Eventually, we started molding those into one speech per week. And to this day, we still get multiple questions from both landlords and tenants, along with social workers, other people that fit into this world as well, but from both sides of the equation. And we stopped doing them twice a week. Obviously, it wasn't as important to do it as often. But we've tried to target our dates for when we knew things were going to occur, like we're doing one this week, largely to talk about the CDC suspension and where that's at legally. But we're also going to do one next week. And the reason why we're doing two in a row is because of the fact that the state session is slated to end Monday. And those end, when they hit the end point, they end. There's special sessions happen frequently, at least in my lifetime working in this world, but the actual session does end Monday night at midnight, and so we'll fill you in with what we know next week, and that's why we're doing 2 of them. But I did want to mention that this was our 50th version of this, and I'm sad that we're still needing to do these. I had hoped, like the rest of the world, 11 months ago, that this was going to be a short-lived experience for all of us, but here we are. And as always, we are trying to inform people about the status of things, where they are, and let's do that now.
Yeah, and
So
I
go
was just
ahead
gonna
and-
say 50th anniversary is traditionally the golden anniversary. So that's
Okay,
yeah.
you're
So
giving me gift giving
no,
suggestions
we're
here,
just,
or
it's not, you mentioned a bottle of champagne earlier. It's gold is the proper gift for 50. So, oh yeah,
Got it.
moving on. Yeah.
Thank you. Yes, let's talk about the state suspension first, because as we've always framed this, the question that really matters in landlord-tenant law about COVID-19 specific rules are, when will landlords be able to file non-payment of rent evictions again? That's the most important question we can really try to answer. The reason why that's so important is because evictions, despite leases being lengthy many times, these days we're seeing 50-page leases somewhat regularly at this point in history with leasing. But despite that, a 50-page lease, the ultimate tool that most landlords still have in order to enforce much of anything in their contract is to be able to file an eviction. We know historically that evictions are well over 90% filed for non-payment of rent. That's really why landlords file evictions in this state. They weren't created that way. The original eviction concept, then called an unlawful detainer, which predates the Civil War and predates when Minnesota was actually a territory, didn't really envision what we have today, which is using the eviction system as largely a collection effort, is what landlords have, that's where we're at right now. Whether they meant to get there, the court, the landlords, the tenants, that's what the eviction system is really designed to do now. That's how it operates. That can't happen right now. A landlord can't file an eviction just for non-payment of rent, and they haven't been able to since last March. So it's been a long time. And where we're at with the current suspension is, the current one that we have expires in 2 days, on Friday. Governor Walz has indicated that he is going to renew the peacetime emergency. Now, the peacetime emergency is much broader than just evictions. There's all kinds of things that the governor has power to do. There's also things that the state is eligible for because the peacetime emergency remains in place. However, what we're talking about today is evictions, and evictions have been, since the pandemic began, tied by executive order to the peacetime emergency. And so we've been told that the governor, not us, the governor has declared, not in a formal way, because the governor never does that until the actual day that the 30 days is up. The governor has indicated publicly that he plans to renew the peacetime emergency for yet another 30 days, which would put us into mid-June. But the current one that we have officially ends May 14th, which is 2 days away. It's been renewed 14 times already. Could there be a legislative agreement? We're going to talk about that a bit in a second, a little more detail. But sure, there could be a legislative agreement that the governor would sign off on, creating some sort of eviction off-ramp is the phrase that people like to use. The governor could decide to stop renewing either the eviction moratorium or the peacetime emergency. We haven't seen any indication on either front that the governor is going to just unilaterally decide to do that. But I believe that there is political pressure put on the governor from a lot of different sides to end both the eviction moratorium and the peacetime emergency. We see that if you just read the newspaper or look online pretty much every day, you'll see that sort of statement certainly being given by Republicans. I'm not sure if it's being presented by other Democrats, but at some point, the peacetime emergency will end. The peacetime emergency could end, I think, realistically, in 2 ways. The governor's, it looks unlikely, is going to relinquish the peacetime emergency powers, although maybe the vaccination rate gets to a certain level. Maybe the fatalities are so low, the new hospitalizations, the new cases reported are so low that the governor says, fine, we're not going to do any more. That could happen. Also, once again, the legislature could decide to end the peacetime emergency. They've had chances to vote on this, multiple chances since last March. And there's been 7 or 8 formal votes over the year in some months. Every time the Minnesota Senate, which is controlled by Republicans, they hold the majority, has voted to end the governor's peacetime emergency powers, not just eviction moratoriums, but all the peacetime emergency powers. Also, every time the Minnesota House of Representatives, controlled by the DFL, Democrats are in charge, they control the majority there, has voted not to end the governor's peacetime emergency powers. Therefore, the eviction moratorium, along with all the other peacetime emergency powers, remain in place. Again, this isn't just about evictions. The peacetime emergency powers gives the governor the power to say how many people can go watch Twins games, or how many tables can be used in a restaurant, whether a salon can be open, whether a gym can be open. We've seen all these things. We've heard about dials and seen those on social media and in the newspaper, where the governor talks about throttling back, throttling open, depending on the numbers on the ground, the information that we have. The vaccination rate being the newest driving factor in deciding what can or can't be done, that the governor is sharing with all of us. So either one of those things could happen. We could also have a court challenge. There have been court challenges, none successful, against the governor's peacetime emergency. We certainly would know about that if that had happened. But there have been attempts at that. There have been attempts at that virtually every state in the country, I imagine. I haven't really dug into it that deeply because it doesn't truly affect our state that much. But a court could declare that the peacetime emergency has to end, or needed to end, or should have ended already. But that hasn't happened yet. But a successful court challenge is a possibility always when we're talking about such weighty, sort of at the core of the Constitution of the state issues. Yeah, let's go on to this next slide here, Eric. And I think you're going to talk more about this one than me, so I'll let you chime in.
Sure, yeah. So continuing the question, when will most evictions for non-payment be filed? I'm going to put some resources in the chat, so folks, some folks maybe have been following this, but if not, you'll get some resources here. There are 2 bills at the legislature. There's more than that, but there's 2 kind of competing bills at the legislature, one in the Senate and one in the House. The the Senate bill, the House bill was, the original version was introduced, I think, in one of the first days of session, and it was amended a couple times. The Senate bill was, and it's gone through, I think, most of the relevant committees. In the Senate, there was a bill introduced, Senate File 1470. The House bill was House File 12. And then Senate File 1470 went through the Senate committees and then passed the full Senate floor sometime in, I believe, April. And so now they've set up a conference committee because there's these 2 competing bills. So I'm going to post some information about that. The important thing to know, I guess, right now is that there is quite a bit of difference in between the 2 bills. In short, the Senate bill creates a timeline. Well, first of all, it does something outside of kind of the current suspension. It actually would create some permanent change in how in the future governor's ability to initiate emergency orders in times of peacetime emergency in the future that would impact evictions and other tenant landlord laws. So it makes kind of a permanent change there. But then it would also set up, an end to Executive Order 2079, and then create a phase out over sort of a 30, 60, and 90-day timeline, opening up different various types of non-renewals, lease terminations, and different types of evictions that would open up over the 30, 60, and 90 days. Some of them relating to the ability to start lease terminations and evictions for folks who might not be eligible for rental assistance. It also creates a protection that right now the bill runs until June 1st, 2022 for this protection. And what it says there is that if a tenant has a pending application with perhaps Rent Help MN or some COVID-19 emergency rental assistance, then an eviction for non-payment is prohibited. So it kind of sets up that protection so that folks can get the rental assistance, because it is taking some time. I know there's some questions actually we got about the timeline that the rent help is taking. And, that's similar. The previous program, CHAP, COVID Housing Assistance Program, that was set up in September, fall of last year, August, September, something like that. That we heard from our clients and from community members that it did take a good amount of time for some of the dollars to get out the door, over a month. Sometimes we heard even longer than that. So it's a large amount of money, a lot of applications is what we're hearing. And so it is taking time. So that's why the Senate bill has that provision in it. The House bill that is kind of aligned in this conference committee, that was originally House File 12, and now it's aligned in this conference committee with the Senate bill, does a number of other things. First of all, what it does, it does quite a few things that are different than the Senate bill. I guess one thing that it does that is similar, there's a couple things that does it similar. The bullet point on this slide, both of them would start to allow certain types of evictions, in particular for material breach or material violation of the lease. It would start to allow those. The other thing that's somewhat similar is that there is again a similar provision in the House bill that would create kind of a protection again for tenants that could be getting rental assistance, but it's taking time for them to apply to receive the funding for the landlord to get the rental assistance, because we know it takes time for that to roll out. So it would protect folks from eviction in those type of circumstances, kind of similarly to the Senate bill. Senate bill pins it on a specific date, June of next year. The House bill says 12 months after this, the peacetime emergency ends. Another thing that the House bill does is it actually it kind of pins the current, somewhat similar to the current Executive Order 20-79 with the addition of material breach evictions to the peacetime emergency. So as long as the governor would extend the peacetime emergency with the thinking that there's still a concern of a public health emergency, then most of the provisions of Executive Order 2079 would continue for the time being. When the peacetime emergency does end, then it would set up this 12-month period, which would create some additional protections. It would create a notice period, required notice period prior to eviction for non-payment. And then it outlines what that notice has to include. So I think what we've heard is the kind of the purpose of that notice, again, is, not everybody is tuning into our webinars on a weekly or every other week basis. Not everybody's monitoring the conference committee and the bills that are coming up. And not everybody's monitoring when the peacetime emergency gets renewed or doesn't get renewed. So there's a lot of folks that, everyday folks are not following that. So some sort of notice requirement that says, hey, the peacetime emergency has ended, you owe this amount of rent, and then tenants can then use that notice to secure rental assistance through the current program or potentially future programs. There's a variety of other provisions, but I think I probably outlined more than you needed to know for right now. I guess the important thing or the additional thing that I'll add, and I'll put in the chat, I'll put links to each version of the bill, the House and the Senate bill, and then also the conference committee. So again, how the legislature works is these bills, went through relevant committees in each body, in the House and the Senate, Housing Committee and Civil Law, et cetera, the committees that oversee these provisions of state statutes. And then one was passed on the Senate floor, and the House had a different version. So there's basically different versions of a similar policy. So a smaller subset of legislators from both the House and the Senate are named to try to come up with a solution to negotiate a shared language on the bill, so that then both bodies potentially would agree to it. So that conference committee, the members of that conference committee were named yesterday. They are Representative Hausman, Representative Howard, Representative Tice in the House, and in the Senate, Senator Draheim, Senator Duckworth, and Senator Dietzig. So I'll send the link to that, the page where you kind of monitor what's going on with that bill. And I think I covered everything, and I'll hand it back over to Mike.
Okay. let's talk about the federal moratorium on evictions next then. So as mentioned, hurdle one for a landlord in Minnesota to be able to file an eviction would be to get past the state eviction moratorium. That is the primary and in most cases only hurdle that matters when it comes to that question. Can a landlord file right now? The CDC federal moratorium on evictions explicitly defers to a state moratorium if the state moratorium offers more protection to renters. It covers the entire United States, the CDC order does. And so it has been in Minnesota largely a backstop, a theoretical backstop that if the state moratorium ends, well, the CDC moratorium is still in place. It allows a lot more evictions than the state moratorium does. We're not talking today about the exceptions to the eviction moratorium in Minnesota. I'll mention them briefly, but I don't want to dive into them deeply. First, a landlord can file an eviction against somebody right now in Minnesota if they substantially endanger others on the property, if they cause significant property damage, if the landlord or a family member needs to move in, and if the tenant violates an old statute from the 1990s, banning a tenant from having any illegal drugs, illegal weapons, prostitution, contraband in the property. Those are the only exceptions that exist. But again, going back to the non-payment cases, because that's really what evictions in Minnesota are about. If the state moratorium were to disappear immediately today somehow, the CDC moratorium is still legally in place until June 30th of this year. Now, the CDC moratorium started last September is when it first took effect. It was announced in late August and took effect in last September. And it has been challenged multiple times throughout the United States. To date, I know of 4 favorable rulings for the landlord side on the CDC moratorium. So the landlord's always arguing that they should be able to evict for non-payment of rent, that the CDC moratorium shouldn't be able to stop them. There have been a couple different approaches to these arguments. The one in Texas, so looking at our screen here, we've got the Turkle case in Texas. It was sort of a kitchen sink list of complaints about the CDC order. Contracts clause, commerce clause, undue taking, no due process. The kind of arguments that you see used a lot in constitutional law argument cases. They don't always get traction, but those are the kinds of things that people use. And the Texas judge ruled in favor of the landlord. There have been several other cases around the United States with the same approach taken by landlords where the landlords did not win, where the government was, the moratorium was upheld. I don't think that those are very strong, compelling legal arguments, having read both the plaintiff's argument, the defendant's argument in those cases, and the decisions that have come down. I don't think that there's enough there for a landlord to really have a great shot at the Court of Appeals level or even at the federal Supreme Court. However, in the last couple of months, we've seen a different approach taken by landlord groups in challenging the CDC order, where what they're challenging is not these grand sort of underlying constitutional themes, but instead looking to the source of the CDC's original statutory power, the Public Health Service Act, which is what enables the CDC to do much of anything that it's empowered to do. There are specific things listed, enumerated in the Public Health Service Act. So the CDC is able to stop crops from going from one state to another, or livestock from going from one state to another. That kind of stopping disease and isolating it and limiting movement seemed to be the theory behind the powers that the CDC was granted. So using that argument to say no evictions for non-payment of rent, I think it's possible to stretch that argument for this in favor of the CDC. One would argue that, hey, look, if people are evicted, they're more likely to scatter, right? They've just lost their home, their tether, their anchor. And so they're going to look for something new. That might mean that they need to move back to where their family's from. Maybe somebody in Minnesota might want to move to Chicago or to New Orleans or Los Angeles because that's where they grew up. And that's where they know that they have somebody to live with because they can't afford to stay where they are. and they've lost their home because of an eviction. I guess that's the best argument the CDC could make. But strictly analyzing the CDC's authority under the statute that gave them the power to do those things, in my mind, has always been the best attack that landlords or landlord groups could mount against the eviction moratorium declared by the CDC. So there's a fourth decision that's come out. And let's go to the next page with the map, and then I'll talk about that fourth decision. All right. So we've talked about this before, but briefly I'll cover this. There are officially 12 districts in the United States. You don't see number 12 listed on there. If you look down in the south, you'll see number 11 is counted, but the 12th is the DC Circuit. And that's where the latest case has come from. Why we care about these maps, in theory, a decision in a circuit is supposed to be binding on that specific geographic area, more so than any other area. It can be persuasive or instructive to judges in other districts or circuits. But we had the Texas decision, which is down in the 5th district. We had the Ohio and the Tennessee decision, both in the 6th district. And now we have a DC Circuit decision. You'll notice Minnesota is in the 8th district. We haven't had any adverse CDC rulings that I'm aware of. Again, these happen a lot. So I know that one was filed in Iowa. I haven't heard any results on that. And so we don't have anything in our district that looks like it would be compelling enough to force a federal district court judge in Minnesota to rule against the CDC moratorium, assuming the state moratorium went away and suddenly the CDC backstop was the key question to try to figure out, could a landlord file an eviction for non-payment of rent? Now, go on to the next screen, if you would, Eric. So we're talking about the DC Circuit Court case. If you want to look it up, it's easy to find, Alabama Association of Realtors. You just Google up that plus CDC, you're going to find this case. It referenced the Ohio and Tennessee cases. The decision was given by Judge Dabney Friedrich, a recent Trump appointee. And her decision, I had to look that judge up. I don't really know federal judges. It's not the world I work in. And this is only the second time I think I've ever seen the name Dabney anywhere. I, of course, am old enough to know of Dabney Coleman, the actor. And that was a guy. This is Judge Friedrich is not. I guess Dabney's can go in both directions for a name. I just haven't heard that name much before. Anyhow, her decision followed the Ohio and the Tennessee cases substantially. And she, I thought, did the best job I've seen of any judge, really boiling down the essence of the landlord's argument, which is, I don't think the CDC original statutory power authorizes them to do this. That's what she decided. And unlike the judges in Ohio and Tennessee and in Texas, she said, you know what, moratorium off for everybody. She issued a blanket order. Several hours later, the Department of Justice filed for a notice of appeal and asked for an emergency stay, and that was granted, which is not that uncommon for situations like this. In theory, we're supposed to hear today if there's going to be an extension to that stay, if it's going to go on from May 12th on, or if there's going to be that stay is lifted. It is supposed to be issued today, according to the original stay decision by Judge Friedrich. So this is a much more broadly applicable decision. The reason why is the judge stated that in the decision. Earlier cases, the Ohio, the Tennessee, and the Texas case all said, we're really answering the question about these plaintiffs right here, trying to limit the answer to the question that they were being asked to provide an answer for. But Judge Friedrich's decision was not limited anywhere near as much. Now, the DC Circuit is generally seen as maybe the most important circuit when issuing decisions. Still, they don't have any official binding authority over the 8th Circuit where we're at. But in my mind, the CDC order is absolutely in its weakest position right now from a judicial questioning standpoint. It's been challenged several times through courts, sometimes successfully. The natural evolution of an issue like this would probably be, in most cases, that there would be appeals to the Court of Appeals, and those are occurring. The DC Circuit, I know that the Texas case was appealed, and I believe the Ohio and Tennessee cases were appealed as well. But if you start getting authorities from different courts of appeals, we've been talking about district court cases only. Those are the entry-level courts when you get to the federal level. The Court of Appeals is the next level up, followed by the Supreme Court. There's other things as well, other types of courts, but those are the three big types of courts that we have at the federal level. So let's say that we get this kind of split at the Court of Appeals level, where the Sixth Circuit says one thing and then the DC Circuit says a different thing at the Court of Appeals level. Those are the type of cases that generally have a very good chance of ending up in the US Supreme Court, where they have absolute discretion to decide whichever cases they wish to take or not. To my knowledge, there's only one type of case that almost always is guaranteed a Supreme Court hearing, and that is a dispute over boundary lines, believe it or not, state boundary lines. And these disputes happen. They still happen. To this day, they still happen. Mainly because rivers move. Rivers change. They just sort of evolve over time. And if a river decides to take a different route, that could be the difference between a new border between Minnesota and Wisconsin. And so they actually have special magistrates that are sort of river/map experts, and they try to answer those questions. But officially, those are Supreme Court cases. Anyhow, everything else, the Supreme Court decides yes or no, we want to hear these cases. And so they have absolute discretion to take them. But these are the types of cases that they would generally hear. These cases aren't moving fast. I mean, they're not going blindingly quickly. I mean, we've all, I'm sure many of us remember, for instance, the 2000 election, where there was a great deal of that was contested, and the Supreme Court took it up very fast because it was, the utmost constitutional importance. And there was an urgent need for the Supreme Court to get involved, but those sorts of things don't happen often. Usually going through courts takes time. And that seems to be how it's working here. I don't see any fast or excessive fast tracking occurring. So again, the weak link for the CDC eviction moratorium, in my mind, is, does the original statutory authority granted ultimately by Congress and signed by the president, whenever that was, I think it was the 40s, does that authorize the CDC to issue this blanket eviction moratorium? Now, I think there's one argument that might hold up for the government ultimately. And to get to that argument, you have to know sort of the versions that we've seen of the CDC moratorium since they began. The first one was issued in early September. That's when it took effect under President Trump. That expired on December 31. And it was renewed through January 31. The renewal, though, was not an edict from President Trump. It was actually congressionally approved. It was part of the big budget agreement to extend everything for a month, basically, until the new president was in power. Or at that time, I'm not sure that everybody in the Senate and the House of Representatives was even convinced there was going to be a new president at that point, but they wanted to delay the decision making. So Congress reauthorized lots of things, but one of the things they reauthorized was the CDC eviction moratorium. So Congress did, in fact, at one point, give their stamp of approval to this eviction moratorium. After January 31, President Biden unilaterally, through the CDC, extended the eviction moratorium through the end of March, and that has been extended once again through the end of June. There had been rumblings that it would be extended through September. That hasn't happened yet, obviously, and we're not sure that it will happen. Again, I think a lot of that depends on the analysis of what's going on in the country. What's the vaccination rate look like? How many fatalities? How many hospitalizations? That sort of thing seems to be driving a lot of this. But if I were on the government's payroll as a DOJ attorney, arguing why the eviction moratorium should withstand the challenge in the DC circuit or in Tennessee or in Ohio, my first argument would be, well, wait a second, Congress did authorize this. Only one out of the 4 times, but they said it was okay once. And they don't feel a need to re-stamp it each time. They figure the president can just keep doing it. If they wanted to stop it, they could have, and they didn't. They reauthorized it. This was an affirmative decision on their part, on Congress's part, that wasn't truly forced on them. The president could have unilaterally extended it for another month without them. We've seen President Biden do that as well. So Congress did authorize this once. That would be my best argument to the counter of, hey, the CDC doesn't have this power. Well, they did at least for 30 days from Congress. And that was, again, passed by a Republican-controlled Senate, a Democrat-controlled House at the time, and a Republican president, President Trump at the time. Which brings me sort of to an overarching analysis of the CDC moratorium. It really is bipartisan. More than most of the things that we talk about at any political level anymore. This was introduced by a Republican president. It has been extended by a Democratic president, and it was endorsed by a Republican Senate and a Democrat House. So this is about as bipartisan as we get, like I say, with this sort of contentious type of issue. Now, landlords are upset about the eviction moratorium on a lot of levels. Not every landlord, of course, but many landlords. And we hear representatives of landlord groups talking about how they need to wipe out the eviction moratorium, that it's done its job, that there's not going to be a cliff, which I think is at best hopeful and at worst wishful, and ignoring the unknowns of all of this. But that's an assessment of where we're at with the CDC moratorium. We might know more by the end of the day, literally. Another one of the reasons why we're going to do another speech next week is because we might have heard. I, in fact, have a couple of attorneys standing by today, and they're supposed to let me know mid-speech if we get the decision about the extension of the stay. But we can't rush that decision from being made, obviously. So, plus again, we have the state version, which may be radically different by this time next week. If there's an agreement reached by Monday night, then we could have a brand new version of a state moratorium, if there's a state moratorium at all, or if there's an off-ramp built where it's a gradual shift into no evictions. We'll know a lot more in 7 days, or at least we'll be able to update you on where things are at in 7 days, because there will be some changes from where we are today. I think that's pretty certain. Okay, I think that's it for my deep dive, multicolored map analysis.
All right. Well, before we get to questions, and we have some submitted in advance. And again, if you have questions, submit them via the Q&A thing over Zoom. There was just, I guess, one more thing I wanted to mention on the slide that I talked about that I sort of didn't cover, which is probably the most important thing. And that's, again, that conference committee that's looking at the potential off-ramp bill, that was just named yesterday. They have not yet, from my understanding, not yet scheduled a meeting. And the regular session of the legislature ends on Monday. It's supposed to end, I think, at midnight on Monday. They have a lot of other business that they have to do. I think there's been plenty of articles in the paper, in the news about, that there's a lot for them to get done in time, and that it's possible, very possible, could go to special session. As Mike mentioned, there's going to be what we've heard is reported in the news is that Governor Walz intends to extend the peacetime emergency, which ends this Friday, another 30 days. So that would mean that the legislature has to come back in June to do a special session if he were to try to extend it again then too. In any event, what I'm trying to get at here is just that committee really only has until over the weekend, really, and they have to get to an agreement, because then both bodies, the Senate and the House, if they came to an agreement in that committee, would have to vote, would have to go to both the floor of the House and the Senate. So a lot of work to be done for them to come to an agreement, not a lot of time. So that's sort of where we're at, but we may have more news on all of these things next week, next Wednesday. All right, so jumping over to my question list here. Yeah, so we have 6 or 8 questions sent in advance, so we'll get to those now.
But plenty of time for more questions. So please feel free to submit in the Q&A if you have a question. We almost certainly will have time to get to it today.
All right. We have a question, actually a pair of questions from Lynette. So let's start with the first one. Will this pandemic change the way even big management and owners screen or what they accept for income? For example, rules like you must make 2 or 3 times the rent in income monthly, or that unemployment income counts like any other source of income. That's the first question.
Right. Pretty broad question. Hard to know. I mean, first of all, on some level, we're seeing some city rules that are addressing this very issue. What income levels can a landlord go to? Minneapolis's ordinance that was passed on this remains intact. The St. Paul ordinance was challenged successfully at the federal district court level and is being appealed with a similar type of allowance for what a landlord can require for an income multiplier. You need 2 times the rent for income or 3 times the rent for income. Historically, when do we see landlords change their screening? I honestly think there's some market forces at work when it comes to that question, more than maybe anything else. I mean, there can be legal changes to it. But when I see landlords start to relax their screening criteria is when the market isn't as good for them in general. That's a real oversimplification, but it's not wrong. If landlords have 1 out of every 100 apartments empty, a 1% vacancy rate, we see screening criteria tighten. We always have. We've always seen the landlords get stricter. Your evictions have to be paid off or else no evictions at all. Your criminal record is more closely scrutinized, more recently scrutinized, and goes further and further back. The credit score has to be higher. When the vacancy rates are low, landlords tighten their screening criteria. When the vacancy rate goes up, then landlords start to relax some things. They relax their screening criteria because if they've got 5 empty units, well, would it be so bad if we let somebody move in with maybe not the perfect credit because we need to get somebody in there paying rent? So let's at least let those folks in. Yeah, landlords will change their screening criteria when the market conditions change, when the vacancy rate changes. I've been doing this since 1996, and for the first time in my career, we've seen some year-over-year analysis of the market showing rent decreases. Now, that's not happening everywhere, but it is happening in some places and big enough numbers to actually show a dip. So average rent in the Twin Cities metro area hovered at about $900 for, I don't know, 15 years, roughly. It never went down though. It always just sort of flatlined, maybe go up $1 or $2. In the last 5, 6, 7 years, the average rent, depending on which form or survey you're looking at, it's between $1,250 and $1,400, much higher. And there's been a steady escalation in rent, partly because there was this stagnation of rent amounts for that long. But over the last year, over the last 15 months, maybe even 18 months, prior to the pandemic even, we've started to see some rents going down. Now that doesn't happen if the market is amazing for landlords. Landlords don't just voluntarily say, hey, I want to start giving my good tenants a discount. They're lowering their rent because they feel like they need to attract customers. And so screening criteria, I think, are one of those things that can change when the market is worse for landlords. Now, who knows what the market's going to look like when things start to get normaler in general for our country. I think that there were a lot of people that doubled up during the pandemic. They moved in with family for health reasons, for economic reasons, for sanity reasons, all kinds of reasons. But maybe those people are going to want to go get their own place again that we're doubling up. So maybe we'll have a flood of new applicants for apartments. Hard to know. It's one of those things that's really hard to predict. It's easy to analyze once it's happened. But I think that there's a chance that we'll see landlords lowering their income screening requirement. That's possible. I think the credit score usually is the first victim of the tight screening. Landlords tend to look at that as the least important of their screening criteria. I think evictions are the thing that they look at first in most situations. But that's a long answer to a pretty direct question. But I know that Lynette had another one you said.
Yeah, and it got cut off a little bit, but maybe we can still try to get the gist of it. What can I do if my landlord forced me to sign a lease last April in 2020, increasing my rent $150 per month? I was unaware, and then it got cut off. Maybe that was, I was unaware at the time, because I think the price gouging order went into effect in March. So maybe that's what they were unaware of, or they,
Yeah. So yeah, there's a price gouging executive order that's been in place since the eviction order and the peacetime emergency. That was, I mean, if you go back in time a little bit to the toilet paper shortage of last year, that wasn't the only thing that people were concerned about. I mean, if you went to the grocery store then, strange experience for a lot of reasons. The first time you went to a grocery store and lots of people wearing masks and gloves and looking at each other suspiciously, but the aisles were empty in many aisles, in many stores. Toilet paper, paper towels, dairy, meat, soup, right? There were limits on how many cans of soup you could buy. And so there were price, that's always a concern for society. When there's a pandemic, when there's a war, when there's a threat of a hurricane, you'll see that in Florida, where all the shelves will be, stripped empty of food. So maybe an enterprising, pure capitalist merchant would say, aha, hurricane's coming this weekend. You want to get a can of soup? It's going to cost you $100, right? And somebody will pay it. Somebody will pay that $100 because they want to make sure they can eat that weekend. They didn't have anything in the cupboard. So there was a price gouging rule put in place by the governor, not especially surprising, that for goods or services that were essential, there couldn't be more than a 20% increase in the prices from that time, that price before the pandemic was declared. And so, yeah, we've seen some of this. This hasn't been as big an issue as one might suspect, but we've seen some of it where landlords are raising their rent and the price gouging rule remains in place. So the problem that I'd have if Lynette were a hotline caller, again, I run a tenant hotline. That's what one of the things that Homeline does. And I talk to people or read emails that people send all the time. One of the things I'd have to try to pin down is, okay, how much was the rent before? Is $150 above the price gouging cap? And if it is, then, well, you could file a complaint with the Attorney General's office and they could take action against the landlord. I don't know what they do with one so retroactive, though. If you've been paying the increased rent that long, I don't know what exactly the AG's office might do. They might try to negotiate something between the landlord and the tenant saying, hey, landlord, you weren't supposed to go above 20%. You should return everything above 20% to the tenant that they've paid and keep it at that level until the peacetime emergency is over. Might be one way to try to resolve this. The penalty actually in the price gouging statute, I haven't looked at it in quite a while, the actual executive order, but it was substantial. It was maybe like $10,000 for a violation. It was a massive number. But that's the once again the long answer.
All right. Nicole, a tenant, asks, how is it possible to have an eviction that didn't happen and I wasn't on the lease and it wasn't on my record from 2015, but now it is?
Okay. So yeah, this is one of those things that we hear about occasionally from callers or tenants on our hotline, that they find an eviction that they didn't know about from their past. And one might think, well, wait a second, how do you not know about an eviction on your record? That doesn't make any sense. You're just kind of wishing it away. Well, maybe you had a dispute with a roommate and you left the rental mid-lease. But then the roommate didn't pay the rent next month. And so the landlord filed an eviction. And when they filed the eviction, they filed it against the remaining roommate, but also against all the earlier roommates that were on the lease as well. That might be the kind of eviction that we'd see where somebody didn't know an eviction was actually filed against them. They were never served anything. It was served physically at the property, but they're not at the property. They're not in contact with that roommate. Maybe it was a romance that had gone bad. And so they don't want any connection at all. So there's no contact whatsoever. A lot of times, even if it wasn't a romantic thing, the remaining roommate doesn't feel great about things. They sort of turtle up a little bit. They don't want to share it with everybody. And so they figure, well, why do I broadcast this? I'm just going to leave because the eviction was filed. And so there's an eviction on somebody's record. So in Nicole's situation, I'd strongly recommend that she contact us. You see our tenant hotline phone number on there, along with our free email and attorney service that you're welcome to send us an email to. We'd want to see some details about the eviction that occurred. Would be the first thing. There's a chance that you could get that expunged. Maybe it's possible. The other thing that I'd recommend or mention is that an eviction from 2015 is starting to become irrelevant on its own. The screening companies, the ones that landlords tend to hire, if you're paying $25, $30, $50 for an application for adult, chances are strong that the landlord is hiring one of the screening companies that does this kind of work. And those companies can only report an eviction for 7 years. And so we're getting close to that 7-year mark for Nicole, where the eviction would have little impact. If she's looking for a place today, that doesn't do her much good. But if she's worried about this and wondering if she can get it removed because she's going to move in 3 years, I'm not sure how much it's worth it for her to try to get the expungement. She can try, but there's some effort involved in getting an expungement for sure, and it's never a guarantee.
Right. Deborah, a landlord, it looks like, is asking or saying they gave a tenant the option to renew their lease. The lease expires July 1st, 2021. How will this landlord know when the executive order is lifted in order to notify the tenant to vacate?
Yeah, it's a great question. So I don't know, does the peacetime emergency extension, does that make the front page of the Strib anymore? In general, Eric, what do you think?
I mean, it probably will this month because of the end of the legislative session.
Right.
But yeah, it hasn't necessarily throughout the pandemic. So
Yeah, it's not exactly front page news anymore to read that a Democratic governor is extending a peacetime emergency right now. And so it's actually a fair question that Deborah's asking. How am I going to know when the rules change? Well, I guarantee you that we're going to be doing this. So if Deborah's a longtime watcher of this ongoing series, we're going to tell people, oh, hi, Deborah. She's in California. Yeah, it's even harder. Although the good news for Deborah is that, wow, she did that in all caps. She seems so angry. The good news is that social media makes news and following news a lot easier from afar. This isn't going to be the kind of thing that anybody's going to be hiding. Once the peacetime emergency ends, once the ability to evict ends or is allowed again, I think it's going to be really loudly telegraphed to the world that cares. I guess you could check every month or so, but yeah, it's a fair question. It's honestly one of the reasons why we started doing these presentations and why we continue to do these presentations is because the rules have shifted. Sometimes they've shifted quickly with very little notice, and we're trying to let people know what the rules are. We tried to keep these not especially political. Obviously, we're tenant advocates, and we had hope for things that favor tenants, but the design of this specific program is to more or less be saying, here's what the rules are. This is what we think that the rules are right now, so everybody knows what rules people are playing by. And so we're going to try to keep doing that same thing. And like I said, I don't think there's going to be any lack of publicity, certainly in the landlord-tenant community when this changes, which it eventually has to.
yeah, and I did put in the chat, just we do have that page on our website, which is we update that when we find out any sort of news related to the suspension, and including the state and the federal CDC order, and as well as if there's news on rental assistance. But if you want to look yourself too, I'll put and I put it in the chat the page on our website, but also this page on the state Minnesota legislature's website is where all of Governor Walz's orders are, and the most recent are on top. So if you go to that right now, you see order number 2120-21, which is the one I think I think that's the one that was announced last Thursday, where there's, mask mandates going to go away if we hit certain vaccination status or by July 1st, et cetera. Of course, that order did not do anything to impact the 2079, the eviction suspension order. All right. April, it sounds like April's a tenant and has been given a 30-day notice, I believe, due to the landlord passing away. No legal reason. I think due to landlord passing. April's in here and chatting with us, so if we get this wrong, let us know. No legal reason. What happens if their family is needing the house to occupy?
Yeah, so I mean, deaths occur, obviously, and we deal with that when a tenant dies or one tenant in a family dies in a household. But landlords pass away too. And it can be often very confusing what the remaining tenant and the estate of the landlord is supposed to do going forward. And in April's situation, so the landlord dies, and her concern is, what if the tenant, or what if the landlord's family, I guess, needs the house to occupy? So what April's asking about is the executive order exception from Governor Walz in 2079, which Eric just mentioned. If you want to look up any executive orders, they're super easy to find online. You just Google them up, or he's got the links to them as well. But executive order EO 20 was passed in 2020. 79 was the 79th order. It has some exceptions to the eviction moratorium. One of them is that if and I'm going to just pull it up so I make sure I have the language of this right. I don't read it every day. I used to, but it's a little more ingrained in my mind right now, and you get sort of used to knowing what's there. Yeah. So what that order says is that if the owner or the property owner's family members need to move in, is the language that we have here. I'm sorry, just making sure I get the right portion of it here. Yeah, due to the need to move the property owner or their family members into the property. So there's a possibility of a family member exception playing a role here. And it's exception number 4 in the peacetime emergency, but it overrides paragraph number 3. April mentions in the chat that she's only looking for an additional 30 days. It depends. First of all, the owner's family still has to give a notice of at least 7 days, maybe 30 days, depending on what the original lease said. If there was a lease and it had a notice requirement in it, that might still play a role. If it was the middle of a year lease, if it was the middle of a 1-year lease, then the owner's family probably would still need to uphold the contract. And so the first step that I would take if I'm in this situation, I'm going to look at the lease to see exactly what it requires for notice. That still might play a role. I guess there's one other factor that I would put in mind. Sometimes we talk to tenants and their goal is literally to get more time. They need 2 weeks, they need 3 weeks, they need 4 weeks more, and that's it. They have another place lined up. Maybe they're buying a house. Maybe they're buying a house and they're going to close within 30 days. And they don't really care that they get an eviction on their record. I think there's a couple approaches that tenant could take. Number one, they could go to the owner's representative at this point and say, here's when I'm going to move. I already have a closing set. I guarantee that I'm going to be out by this day. Can you guys hold off the eviction? Save yourself $300. I'm going to be gone. You can see the paperwork. It's real. I'm not making it up. And a lot of times the landlord will just back off and they'll negotiate something. Or the landlord could go full steam ahead and go file the eviction. Evictions don't happen in a day. They take, on average, at least they used to, 20 to 30 days. Who knows how long it'll take right now? It's probably very county specific how long it would take for an eviction. But 20 to 30 days is still probably a reasonable guess in many cases, at the minimum. So you might get that more time, but then you'd have an eviction on your record as a tenant, so there's a risk. So there is a chance to get more time if the landlord's family, in my experience, if they seriously believe that you're going, then they're much more willing to say, okay, you're going to go by that date, we'll hold off. And in truth, landlords don't really believe stories like this. I'm going to go, you can, I trust me, I promise. What they believe in is boxes. Landlords believe in boxes. If they swing by and it looks like you're packed up and ready to go, that's what they believe in. They don't believe in the story of leaving, they believe in boxes. So if you can, whatever concrete evidence you're able to offer, April, that you're actually vacating might help. But look, we can only go into this so much over kind of a general public forum like this. Please feel free to contact our tenant hotline. It's free, or email an attorney, and somebody will walk through all the nuances of this and try to catch everything you're asking about.
And the number is up on your screen right there for our hotline. Okay, I'm going to let you read that next question to yourself if you think we can answer it. And in the meantime, I'm going to ask a question that Kim sent while you're just reviewing that other one.
Sure.
Kim Tennyson, who is an attorney who's been on our on a Wednesday session, actually 2, I think.
2 out of the 50. Yes.
Yeah. Kim Tennyson is saying, I'm hearing that renthelpmn.org, the website, and 211 are not working well. Has anyone gotten assistance? Homeline, there was a part of the rent help process was that they had community groups come through and apply to be community partners to help help assist people through the application process. Homeline did not apply to be one of those, but we know a number of groups that have, and so they're getting referrals from 211 and elsewhere if there's tenants that need assistance going through the process. I do know just from the experience that we've heard from some of our clients and from some of the community partners that we've worked with, is that the website is, you need a certain amount of computer knowledge and knowledge about how to get attachments and stuff to be submitted. It takes a considerable amount of time to actually go through the process. So it's not the sort of thing you're just going to sit down and plug through in a couple minutes, like an order off of Amazon or something like that. You're going to need to sit down and maybe look through what all the documents are that you might need in advance. And there's a bunch of resources on the website that talk through what you'll need. And so we have heard some hurdles for tenants. There's obviously folks that don't have internet access or don't have the ability to do that over the web. So there is a paper option. We've heard the paper option does take time. So you can request one, I think, by calling 211, but it does take a while to actually get the paper copy sent to you. And then you've got to fill it out and then send it back. There's delays in processing there. My understanding is that, again, it relaunched on April 20th. So we're coming up to 3 weeks or so. My understanding is that I don't think there's been money that has gone out the door yet. At least
I haven't heard any.
Minnesota Housing. We haven't heard from our clients, haven't heard from the community partners that we're aware of yet. This isn't entirely surprising. Unfortunately, the CHAP program that, again, I mentioned earlier, set up last year, did it took a month or more for folks to get funding. So that's what we know. I think there's, if folks are having problems with that, having concerns, you should relay your concerns to Minnesota Housing. Minnesota Housing does have a separate website. I'll put it in the chat about their program. So I'll put a link to that. And there is also some materials on the renthelpmn.org website if folks are having problems, or if they get denied, there's an appeal process as well. I'm not sure if we've had any information about from clients or anyone on how that has worked thus far, but that's sort of what we know. let's see here. We're getting some chat from folks saying that the website had stalled on one of the pages when the tenant was trying to do their side of the application. And then the tenant called 211, and the operator said that it could be up to 2 weeks for somebody for a casework to help. That's unfortunate, but that's where we're at right now. Again, this is sort of, again, it's an unprecedented amount of money that the state and county and local governments have never really run a program like this. And they were really reliant on what the federal guidance they were getting was, that changed a few times, I think, as they were setting up the program. Now there's been this other set of guidance that has come out recently. So that's, I don't know if you have any more to add on that.
No, I think it's probably kind of the steamroller system, right? Where it's going to take a while to get going, but once it gets going, it's going to be hopefully doing what it's supposed to be doing, not steamroll people. That's not the goal, but function as it's supposed to. It just takes time to get moving.
Yeah. So again, this is why, this is not a new thing. From our experience working with our clients, particularly in more dense communities like Hennepin and Ramsey County, before the pandemic, when tenants were facing an eviction and they were seeking, emergency assistance through the county or through other programs, it always takes time, and it takes, in normal times, it took often longer than the eviction process, the eviction court process. So this is one of the reasons why, both of the bills in the House and the Senate have some sort of notice provision. The Senate bill on the off-ramp has a voluntary notice provision. The House has a required one. From our perspective, we think it's a good idea for everybody involved: tenants, landlords, rent help MN, service providers that are helping, and then eventually the courts, if there's a clear notice about how much is owed and enough time to actually get through an application. So that other question, you want me to ask you that one?
Yeah, go ahead. I'm going to give a brief answer to it because there's only so much I can do. It's so specific and it's from a landlord, but go ahead.
Okay, so this is the last one we got in advance, and then we'll get to the few that are in the queue here. We still got about 15 minutes or more. So Kimberly, who I think is a landlord, is asking, or telling us some facts here. 2 unmarried tenants jointly and severally on a lease. Due to moratorium ended and had transitioned. Oh, due to the moratorium, the lease ended and transitioned to month, the tenant with the job who usually pays the rent wants to get off the lease, but the other tenant does not want to leave. Does not want to leave now, but will be vacating at some point. With the current eviction moratorium, we cannot give the remaining tenant notice of non-renewal. The one tenant moved out after disagreement and states that they have a restraining order on the remaining tenant and that we need to remove that tenant because of this. She's also stated she's in communication and has been at the house because of kids. We believe, as she signed the contract, that she's financially responsible for rent and damages, which there will be plenty. We do not have to release her from lease, as that is ending their lease and starting a new one with him, which we do not want. Any advice on that situation?
So a few different things. Number one, again, we're a tenant hotline. We advise renters and their rights, don't advise landlords. We don't want to have a conflict of interest, but I would tell any landlord, if I was giving some sort of public speech, that leases aren't forever. If it's month to month right now, you can't force one tenant to remain on the lease if the other one's going to leave. I mean, it's a monthly contract, and if they decide that they want to give a notice, they can. You don't need both tenants to give a notice to vacate. Number two, there's a domestic abuse statute which might play a role in this answer. The statute number itself, Minnesota Statute 504B.206, might be the way that the tenant has the right to actually get out of the lease unilaterally in this situation. You mentioned restraining orders, so that might be possible. Most importantly here, though, Eric just mentioned Kim Tennyson, who's a landlord attorney. I'd recommend that you call somebody like her because not a simple situation, and explain what you're dealing with and what you're hoping to have happen. And ask Kim, hey, what do you think my options are? What will it cost to help me do what I need to do going forward? And I'm sure she'll tell you what it's going to cost to do that if she can help. I noticed that Kim just posted her. She's not getting a commission from us, and I don't think in any of our sessions that we've actually said call Kim, but no, she knows what she's doing, and I think it would make sense for her for Kimberly to contact Kim about this, so you can get a more thorough answer than I'm able to give here.
Yeah, and I post Kim's website there. The other thing that I'm trying to find the link here, and so I'll post it in the chat. 2 sessions ago, we had a guest speaker on from Legal Corps,
right?
And Sarah Lewis from Legal Corps. So I'm going to find their link to their. They've got a new program that it's advice clinics for low-income landlords, and they have a variety of them scheduled. Here it is. I'll put it in the chat. Okay, I think we're through the previously submitted question, right?
Yeah, I think that's right. Yeah.
Okay, so now we got a question from Tim in the Q&A. What source did you hear from that Governor Walz is going to extend the peacetime emergency? And I've got that queued up to throw in the chat here if I can find it. It's been in a couple media reports, but I think the first one I saw was May 7th in MinPost, and the link is in the chat, but it says in that article in MinPost from last week, Walz said he will renew the peacetime state of emergency when it expires next week. Tim asks, what do you see coming out of the conference committee? Yeah, I do not. This is actually the second time I'm going to say this statement today. I don't have a crystal ball.
Yeah. Well, they're not that expensive, are they?
Okay, for the next webinar, I'll get one.
I never looked into it, but I can't imagine I mean, I'm sure you can pay whatever price you want, but that's what he's asking for, right? A prediction of the future. It's really difficult to know. I don't think that we have any sense of what the conference committee is going to produce, if anything, right? They might just say we couldn't get there. We couldn't get anywhere with an agreement. That could happen. They could come up with something that's more closer to the Senate version, closer to the House version, grand compromise. They blow it all up and create something new, right? All those things are possible.
Yeah. So and again, I went through the timeline a little bit again. The 17th is next Monday. They're supposed to get all their work done, which is not just the eviction suspension, but a budget bill.
Yeah, the budget takes time usually, right? That's usually the big fight.
Right. And so there's a bunch of conference committees that have been announced, and almost all of them that were announced up until yesterday were on omnibus bills. Omnibus bills are gigantic bills that have sort of all the budget and policy provisions that have gone through various committees and generally have passed on either body's floor. So most of them are these omnibus bills with a lot of provisions. There is a housing omnibus bill that has a committee, and actually the makeup of the conferees is fairly similar to the off-ramp bill. Those have been meeting for a while. A bunch of them, like the housing one, I think has only met like once or maybe twice. And some have met more, but a lot of them hadn't been meeting because in order to do their work, they need targets, budget targets from the leadership about what actually is going to be the amount of money that their programs can spend. And that sort of sets the tone for the negotiation about the budget bills and the policies that are in it. So this is a separate conference committee that's just focused on the off-ramp bill. They only have really until next Monday, and really they need to get done sooner than that so the House and the Senate can pass whatever they agree to. If they don't agree to anything, what tends to happen is the leadership of the House and the Senate and perhaps Walz and the Lieutenant Governor Flanagan become part of the negotiations too, potentially. And then I think, as Mike has already pointed out, if nothing happens, well, Walls has said he's going to extend the peacetime emergency this Friday. That'll go till approximately the same time in June. I'm not sure exactly what 30 days is out, but around that time of the month.
There's something about weekends too. I can't
yeah,
remember the rule.
so the session, I mean, if the session ends on the 17th and they don't get the off ramp done, the peacetime emergency will still be in effect. It'll go until mid-June, and
then a special session would be triggered automatically
yeah,
in June if there's no agreement.
Yeah, but they may also have a special session, just a week or a few days after the end of the regular session, because that's happened in the past too. So, but next Wednesday I'll bring my crystal ball. Maybe it'll be too late then, obviously, because it's next week. So, Don is asking, how much proof do you need to file for an eviction based upon the exception that relates to illegal substances?
Yeah, it's a fair question, Don. There's a burden of proof that a landlord has to meet in order to win an eviction for illegal substance. A couple things about this. Number one, the tenant doesn't need enough for resale. They don't need a mountain of cocaine with scales and guys standing around with automatic weapons guarding it. 1 grain of marijuana in the ashtray is enough to evict somebody. And that actually happens, right? The police are called out for an argument. They dump the contents of an ashtray that they see into a bag on the way out the door. They run it through a lab and it turns up that there's a little bit of marijuana in the ashtray. That does happen. That's pretty solid proof, right? The police have run it through a lab. It's been confirmed. The chain of custody is all good. It's not a criminal standard. We all know the criminal standard where you have to prove something beyond a reasonable doubt. This is the beyond a preponderance of the evidence standard. So sort of thinking about it mathematically, the beyond a reasonable doubt, I've seen legal scholars say that's 99% sure or something like that. Beyond the preponderance of the evidence is probably 51% sure. It's more likely than not that is true. So a landlord filing an eviction because they smelled pot in the hallway, probably not a great case for the landlord. It's not impossible to win that case, but it's not the kind of proof. If I were a landlord attorney, I wouldn't want to go in with a case like that. I'd want to have stronger evidence. And the police confirming that a substance that was there is, an illegally possessed substance is usually going to be the starting point for one of those cases, a good strong version of those cases. In fact, those cases don't even get filed that often, because the landlord goes to the tenant and says, I got a winner. Do you want me to go file an eviction against you for drugs or not? You can just leave by next Sunday, or I can file the eviction. Which will it be? And a lot of times the tenant will do a cost benefit analysis and realize that it's not worth it for them to fight for the amount of time that they might get.
Okay. Deborah is asking about another phone number other than 211 for Rent Help MN for out-of-state people. I think there is a direct dial number. I might be able to put in the chat in a moment here.
I think you did, didn't you? I see it there.
Oh yeah. Okay. I think if you go to United Ways, it is the United Way. So it's I think the number. Yeah. Okay. We've got about 5-6 minutes left or so. Here's a question from an anonymous attendee. What if they never come up with an exit ramp? I think maybe we answered that with the last one, huh?
Yeah. Well, I mean,
a couple back.
I think it's a slightly different question. Let's say there's, because what we're talking about, the one that you spent about 10 minutes talking about, the House version and the Senate version, both have the feeling of planning things out to some degree. They use different approaches to it, but they plan things out like this is when evictions are going to start to ramp up again. And maybe it's better to think of it as an on-ramp instead of an off-ramp, because right now we're off the eviction highway, and when are we going to restart the operation of the eviction system again? And so it's going to happen in one of two ways in my mind. It's either going to be a planned out, let's phase things in somehow approach, which both the Senate and the House versions try, or the peacetime emergency will just end, right? And the CDC moratorium goes away, and it's not a planned merge onto the highway. It's just everybody jumps on the highway at once and then goes. So if they never come up with an exit or an entrance ramp, however you want to think about this, eventually that will happen. We will have a pretty unbridled restart of the eviction process. In my mind, both the House and Senate version are better than that. They're both, it's better to have a planned, thought through restart of the eviction system than just plug the machine back in and line the landlords up down the street so they can go file, which is another real possibility. We've seen it in other states when they had an eviction moratorium in place and it was lifted, and then landlords just went and filed the evictions. That system will overwhelm our courts. It'll as an officer of the court, it's a very disturbing concept to me that might be what we have. So absolutely would prefer an on-ramp, off-ramp, however you want to phrase it. But the details are pretty important. So
Pat Long is asking, why is a management company for a larger building now charging tenants extra cost of utilities such as sewer, water, trash, recycle, and administration fee?
So why are they charging those things? Well, larger companies think that they can, is why landlords are doing that. And in many cases, they are able to do that. The administration fee is one that I'd zero in on a little bit there with Pat's question. We've known Pat forever. She's actually one of our board members. And I used to work personally just one door down from Pat. We were in the same office officially at the time. So hello, Pat. The administration fee is one of those things that there was a legislative proposal at the House this year that actually passed all the way through the House, the entire House, right? The banning of fees, Eric, that did get through the entire House, yes?
Sorry, I was looking at something else. What was the question?
The banning of non-discretionary fees by a landlord that passed the Minnesota House.
That is
part of the omnibus bill.
It is part of the housing omnibus bill, correct?
Right. So that proposal would ban all non-discretionary fees by landlords. There's only one other state that has that currently, Delaware, I believe it is. But fees are a growing issue in the landlord-tenant world. They just are. Again, I've been doing this a long time. 10 years ago, we didn't really see administrative fees in leases, maybe 15 years ago. Now they're fairly common. Landlords don't ever define what the administrative fee is about. We got to do stuff. So you have to pay us $300 when you sign your lease because rarely are these fees disclosed in the advertising that landlords do, whether it's on Craigslist or Housing Link or anywhere else. They'll say what the rent is, they'll say what the deposit is, but they don't talk about the fees in the advertising. So they're sort of sprung upon tenants, sometimes very late in the process. Maybe when they see the lease, which might be just a couple days before they're supposed to move in, they've already committed to that place. They can't go somewhere else and get somewhere else to live, so they're locked in anyway, so they have to pay these fees. But administrative fees are different from something like a garage fee, right? Where if you don't want a garage, you don't have a car, so you don't want to pay a garage fee, that's an optional fee versus a non-discretionary fee where the landlord says, this is a fee that's automatically tacked on to what you have to pay. And like I said, they're not always, in fact, I would guess more often than not, disclosed in all the advertising that a landlord will do in the run up to the tenant advertising. So the tenant doesn't know the actual cost of the place that they're trying to rent. As mentioned, it's gone through the House. The Senate has not yet, to my knowledge, heard anything about this. So I'm not sure where it goes from here, but yeah. And I see we got a couple more questions, so maybe we'll try to get those with the time we have left.
Yeah, so before we get to these last two questions, I'm just going to jump ahead and remind folks of our upcoming sessions, and I'll put the links in the chat. Big thing in the chat there. Next Tuesday, a session, again, another free webinar, 12:30 to 2 on Tuesday the 18th. This one is really focused for a specific audience. For stakeholders involved in the Family Homeless Prevention and Assistance Program. And we'll be joined by staff from the Minnesota Engagement on Shelter and Housing, as well as a variety of folks in that program. We're going to have a number of panelists that day. And then a week from today, Wednesday the 19th, again at the same time, the normal time, 1:30 to 3 in the afternoon. It'll be our next general COVID-19 update on what's going on with federal and state eviction suspension. And since the legislature will be ending their regular session on Monday, we'll maybe have news to share. Okay, so jumping back to the question that you just answered, there was a follow-up from Carrie. Does that admin fee apply when utilities are split by a third party, for example, water, sewer, rubbish, as long as it is disclosed in advertising?
So what this question's about is the shared meter issue, which I would point you to Minnesota statute 504B.215 to try to answer. That's kind of the starting point with any shared meter question. There's a lot in that statute, but it's not all about shared meters. And I think Eric is probably pulling up the link for you guys right now. But there is one part that's sort of a checklist, a thing that landlords have to do in order to have a shared meter. And you sort of go point by point. Is the landlord doing this? Are they complying with this? And if they are, it's probably legal for the landlord to do the shared meter. As far as the administrative fee for running it, I think that arguably could fit under the ban of fees, non-discretionary fees that has been proposed at the legislature. But again, that's not the law yet. So, and we certainly haven't had any cases interpreting that law. But yeah, I think that could possibly fit there as well.
All right. Can a landlord management company charge for security, rent, and deposits, but the security / rent is the norm because they are the same amount, but deposits are not given back to the tenant? Why?
Yeah, so I'm not exactly sure what this question is really getting to, because deposits are supposed to go back to tenants when they move out. Security deposit, damage deposit, I assume that's what we're talking about here. That's the tenant's money. The landlord is holding on to it. In fact, they're supposed to pay interest by law, whether the landlord is keeping it in a special account that gets interest or not. They have to pay 1% simple interest on the deposit that they've kept. So the deposit is the tenant's money. They're supposed to get it back. The landlord's got to be able to show somehow that the tenant did something wrong, either didn't pay a bill that they were supposed to pay, like a utility or rent, or if they caused damage beyond ordinary wear and tear. Those are the burdens, and those burdens are on the landlord to prove that they have the right to keep the deposit. So I'm not saying that there's not disputes about this and tenants don't feel unfairly like they're taken advantage of by a landlord keeping a deposit. In fact, that's probably in the top three, well, it is in the top 3 reasons why people call our tenant hotline all the time. I think this is by far the most common reason tenants sue landlords in Minnesota in small claims court is for the recovery of their security deposit as well. There's a lot of disputes about this. A landlord unilaterally keeping a lot of deposits, eventually they're going to get sued quite a bit. Because these are contentious issues. Yeah.
Right. And then somebody asked about, is there any update on the city of St. Paul renter ordinances since it was challenged in court? I don't have any news on that. I don't think, I did see that the city took down a lot of their public facing documents around on their website about it. Have
they decided to challenge or to file an appeal?
I have not heard about that yet. No.
Okay.
We'll try to get an update on that for next week if there is. But yeah, for right now, the court order prohibits the city from enforcing it. So that's where they're at right now. But they do obviously have the opportunity to appeal, and I don't think they've done that yet. But maybe there's news about if they intend to. Okay.
I see that the person asking about the deposit has gotten back to us. I assume it's the same person.
Yeah.
On this one, I'd ask you to get in touch with our tenant hotline. Once again, it's free. You can either email us or call us, and we'll dig deep onto the details of what's going on and see if we can figure out what you've got here. Probably impossible to figure out in a public forum like this.
Yeah, and there's the phone number again, 612-728-5767. A reminder again about renthelpmn.org. And that comes to the end of our webinar. So again, thank you all for attending, and you did get links in the chat about the couple webinars that we have next week. We will post the recording for today on our website, and you'll get a follow-up email on that. And beyond that, I think we're done. Thanks so much for joining us. Thanks, Mike, for covering these topics. Goodbye.